In today's video, we'll talk about how anti-kickback and fee-splitting concerns permeate healthcare arrangements and some ways to spot arrangements that potentially violate these laws versus those that are more likely to survive enforcement. Hi, I'm Michael H. Cohen. I'm founding attorney of the Cohen Healthcare Law Group. We help healthcare industry clients just like you navigate healthcare and FDA legal issues so you can launch or continue to grow and scale your health and wellness business. Now consider a group of medical or psychology practices that offer initial assessments, exams, clinical interviews, or evaluations. They then refer the patient for more detailed clinical services within their group, whether it's a medical service or another long-term type of therapy. The question is whether this violates federal Stark law, federal anti-kickback law, or some state version of Stark or AKS, the federal anti-kickback statute. State laws vary by state, obviously, yet the gist of these laws is usually the same. So first, there's a prohibition against a referral that involves self-interest. This is the essence of the federal Stark law. The law prohibits referring the patients for so-called designated health service, or DHS, in which the medical or other clinical provider has a financial interest. So for example, a referral to a clinical laboratory that the doctor owns, or a referral for physical or occupational therapy, where the physician has a financial self-interest. Now sometimes that self-referral statute will limit the prohibition to certain types of clinicians, such as a doctor of medicine or osteopathy, a doctor of dental surgery or dental medicine, doctor of pediatric medicine, doctor of optometry, and a chiropractor, and only those. Now next, there's a basic prohibition against accepting commissions, discounts, rebates, or any type of fees in exchange for referring the patient to the doctor, psychologist, or other provider. Sometimes a statute will just call this a kickback or a bribe. And there are many variations on this key statutory prohibition, like a prohibition against leasing in exchange for a referral fee. So does your state have such a law? Probably. The federal anti-kickback statute applies to all practitioners, not just physicians, where federal reimbursement monies are involved. There are several important exceptions and safe harbors in each case. So under Stark, for example, there's a complicated exception for IOAS. That's in-office ancillary services, which in a nutshell are services performed by the referring physician or a doctor within the same practice group in certain locations designated by this exception. There are many parts to it. Key exceptions and safe harbors also include a situation where the physician or clinical provider is employed by the referring physician, and that's called bona fide employment. For bona fide employment, compensation also has to be reasonable, at fair market value, calculated in arm's length negotiations, and not based on the number or value of patients referred. Now, yet another important carve-out is for what's called personal services and management contracts. We cover this at much greater length on our blog. It's the basis for the MSO arrangement. If you're interested in an early read on your healthcare model, you'd probably benefit from having a legal strategy session with a member of our legal team. Thanks for watching. If you have any questions, click on the link below, cohenhealthcarelaw.com/contact to send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to speaking with you soon.